Hello, everyone. This is Randy I here, and I'm with my colleague, Rick Schubert. How are you, Rick?
I'm doing well, Randy, and you?
I'm doing very well. So most of you know that I am an employment lawyer based in Toronto, Canada, specializing in assisting employees and employers with matters related to workplace disputes, terminations, harassment, human rights, wrongful dismissal, severance packages, and everything else related to employment litigation. Rick is an employment lawyer, he is a tax lawyer, and he specializes in taxation with respect to the employment law context. And that's what we are going to explore today in terms of our video program. So, Rick, why don't you give me some background as to how you got into tax?
Yes, that was a segue. I started off in employment law, doing very traditional stuff. I started off as an articling student with Stringer Brisbane way back when, and then eventually was hired by one of my clients to be their vice president of human resources and their labor counsel. They were highly unionized employer. From there, I ended up doing a fair bit of work in terms of pensions and benefits as part of the employment law context, and ended up specializing in pensions and benefits. And pension and benefits at the time had just, bill, I think was C-52 came through, was about 175 pages of tax regulations. so that that really became a tax specialty, okay, if you will. That was the predominant. There was provincial pension legislation as well, but one of the predominant driving force really at that particular time was the tax legislation. Similarly with the benefits. So I gradually transmogrified from purely employment law into something that was more focused on taxation. The pension work led to work in other forms of deferred compensation, such as stock options, share appreciation rights, performance share units, et cetera, et cetera. So that's really how that evolved. And so the second half of my career, excuse me, was spent, for the most part, looking at deferred compensation arrangements and the tax, and I also had to be cognizant of the accounting rules. I couldn't opine on them, obviously, because I'm not an accountant. But I found that one of the first things I'd be asked by the CFO was, "Oh, that tax result is nice, but what's the accounting?" So anyway, ended up having to become knowledgeable about the accounting rules as well.
Okay, fantastic. So why is taxation and taxation issues important in the employment law context?
Tax in Canada, we have a system of various tax preferences for employment income. So an employment dollar, a compensation dollar, is not always worth $1, right? At the basic level, let's assume a 50% marginal tax rate. You get to keep 50 cents out of each dollar that you're paid, your compensation dollars. If that's delivered to you in the form of qualifying stock options, you would get to keep 75%, 75 cents out of the dollar. So that's 50% more. So to compare those two compensation dollars, you're really actually looking at a Canadian dollar versus a euro. That's the quantum of the difference and you also have you also have that occurring in benefits, where you've got benefits that are tax deductible to the employer, tax free, tax exempt to the employee. That's the most valuable type of compensation dollars you can get, or the most tax effective ways, they're worth, double, literally double what a regular dollar of compensation is worth. So Canada is somewhat unusual in that respect. And it even has effects on the institutional shareholder services companies. They rate compensation in terms of, how much value are you getting for compensation that you're paying to your executives? Well, because all of these calculations, the methodologies are developed in the States where you have a uniformity of taxation, much more so than Canada. They just look at gross dollars.
Okay.
Right. Here, you really need to look at net dollars, how much net value is being delivered to the employee by way of this compensation dollar. And it varies tremendously.
For sure.
So good compensation design can deliver a lot more net dollars at the same cost to the employer.
Now, when you're talking about compensation design, are you talking about at the onset of an employment relationship, or are you talking by way of settlement? Suppose there's a wrongful dismissal case that's been resolved, and there's a settlement that's structured at the end.
Both, actually. The most of the work that's done in this area, I would say, is in respect of the former. But there's also, in terms of structuring settlements, and in terms of the proper calculation of damages, there's also significant amount of work that can be done in that area. I've been an expert witness in cases where the one of the things at issue, and in respect of which I was retained for, was what was the proper taxation and of a certain LTIP, long-term incentive plan, for the executive, and what type of a gross up was needed in order to make the person whole.
For sure.
Right. And these were U.S. employers of Canadian employees and Canadian executives. And they had put in place restricted share plans, but taxed them as though they were restricted share unit plans. They didn't tax them at the point of grant. They taxed them at the point of when the shares were released to the employee, okay, 3 years down the road. And the difference in one case was $750,000 net. Wow. Damages, and in the other one was I think it was about $300,000. So pretty significant differences in terms of what damages were owed.
Yeah, for sure. Well, let's explore the latter, which is settlement. This would be especially important for my clients who are mostly employees. So often when my firm resolves a case, we structure settlements. The former that you talked about, the compensation planning, usually that's done by employers. And because the majority of our clients are employees, that becomes less relevant. So let's explore the latter first, which is tax structuring. So what are the different ways that you can tax structure a settlement for an employee, say in a typical wrongful dismissal case?
If they still have a defined benefit plan, you can structure part of it as an early retirement window.
Okay.
And when I first started practicing in that area, a lot of plans had huge surpluses, and there was no way, the employer couldn't just withdraw the surplus. So this was a way that the employer could get some use out of the surplus. Surpluses can get so large that you're not allowed to actually put any more funds into the plan. So there can be a strong motivation to find other ways to use it. So we used to structure early retirement windows, and there were the CRA has a number of rules around those in terms of you know, how you can accrue extra service,
Okay.
how much you can gross up the benefits. You can provide literally millions of dollars of additional benefits to employees by way of early retirement windows. And for the employer, if it's coming out of surplus, it's not coming out of their current earnings. And for the employee, it's all tax sheltered.
Okay.
Right. So it's highly effective that way. So, you know, you might give them a bridge benefit that they didn't have before, so that they would receive more pension between age 60 and 65. You could put in inflation indexing, right?
Okay.
You could put in you could change the formula from final 5-year to final 3-year. This type of thing. There's a lot of different ways you can increase the value of those packages. Now, having said that, defined benefit plans are a lot less common than they used to be.
Yeah. Okay.
So,
Let's use a solid scenario. So for people watching at home, they can sort of follow the logic here. So let's suppose the employee is terminated without cause.
yeah,
Hire a lawyer. The lawyer negotiates an improvement to their severance package. At the end of the day, there's $100,000 new money, right, above and beyond whatever amount they've already been paid by way of their employment standards minimums. There's new money, 100,000. That's the settlement.
yeah.
Suppose the employee is entitled to a defined benefits plan. What would be an illustration of how this would work?
Okay. Well, let's assume, for the sake of that example, that the commuted value of the person's accrued defined benefit at that particular point in time is $500,000.
Okay.
And the commuted value is an actuarial calculation that basically is it's the present value of that future stream of income that the actuaries calculate. So $500,000. So the you'll want to use up $100,000 and have it basically all be tax sheltered for the employee and come out of surplus, or be at least fully tax deductible to the employer at the present time. You could, for example, put inflation indexing in.
Okay.
Inflation indexing of CPI minus 100 basis points would probably increase your liability by about 30%, so $150,000. So presto, you've just used that up.
All right. I see.
You used up the full 100,000. No problem at all.
Okay. Fantastic.
Most very few plans. I mean, other than maybe civil service plans, have inflation indexing,
Okay.
because it's such a big increase to the liability.
You've rightly pointed that not many employees, or at least nowadays, fewer employees have defined benefits plans
Right.
with respect to a pension entitlement. Let's suppose we have an employee who has no pension entitlement whatsoever. What type of strategies would you consider in terms of tax structuring a settlement in that particular case?
Well, you could put in, let's say this is a private employer who's got a fair bit of flexibility in terms of how they can do things. You could put in an individual pension plan.
Okay.
And fund some of the benefit that way. Use up a fair bit of money that way.
Sure.
You could put in depending on how much the person was making. If they were making a lot of money, that they were over the allowable pension funding limits, you could put in what's called a retirement compensation arrangement, which is a trust. This can be funded if the employer funds it. The amount they put in to fund the plan is deductible to the employer in the year that it's contributed.
Okay.
and it's not taxable to the employee until it's actually received. So there's tax deferral for the employee's perspective. There is a refundable tax. 50% of the contributions go into a refundable tax account, come back out from that account. That's an account with the CRA. They come back out of that account as the money is paid out to the employee. That's why it's called a refundable tax account. That can have interesting advantages too for if you're dealing with, we have a lot of expat activity. A lot of companies have executives come up from the States, or they might be Canadians who worked in the States and have come back up to Canada and are green card holders. If you're a US citizen or a US green card holder, you're taxed on your worldwide income, no matter where you earn it and no matter where you're residing. The US is unique in the world that way. All the other countries don't tax you on your global income unless you're actually residing in that jurisdiction. So in Canada, if you're residing in Canada as a Canadian taxpayer, you're subject to taxation on your global income. If I give up my Canadian residency and I move to Ireland, I'm no longer taxable in Canada. If I'm a US citizen or green card holder and I move to Ireland, I'm still taxable in the US. Okay. So what happens is you're here in Canada, you're an executive, so you're making a lot of money. You're working, say, in Ontario, you're paying roughly 53% marginal tax rate. My federal rate in the States might only be 30%. So I'm accruing tax credits in respect of the income that I'm earning in Canada for the US purposes. I get tax credits applied to that first 30%, cancels out any tax owing in the States. But now I've also got tax credits for an additional 23%. There's between 30 and 53 in our example. With respect to that, there's a limited shelf life on those tax credits. They evaporate after a certain number of years if you don't use them up. Now, if I have money put into an RCA, a retirement compensation arrangement up here, that's considered to be taxable income in the States when the amounts are contributed into the trust, unlike in Canada. Okay, so that's no problem. I use my tax credits to shelter that from any taxation in the States, right? So, and if a lot of times what people were doing was they would calculate the benefit to be accrued within the retirement compensation arrangement with reference to how much money do I want to contribute to this plan, right? So sort of the tail wagging the dog. But anyway, I say, well, I want to put in $1 million in funding, and the person's going to have 2 years service accrual or 3 years service accrual. And the actuary determines, okay, well, this is what the benefit would, this benefit, 1.8% of final average would be the benefit required to use up that amount of funding.
Okay.
So now so in the States, from the US tax perspective, all that income, right, has been recognized and I've received tax credits. So it's considered to be fully tax paid from the US perspective.
Okay.
Well, when I move back down to the States, right, and I pull that money out of the RCA, I don't have to pay any tax in the States on it. Okay. Right? It's considered tax paid. So, and meanwhile, I haven't paid any tax in Canada yet either. When I pull it out, if it's pulled out as a periodic payments, it's taxed at 50% with 15%, 15% withholding in Canada. If it's lump sum, if I pulled out as a lump sum, it's taxed at 25%. So instead of, in respect of that money, right, instead of having paid 53% in Canada, I've only paid 15%, and I pay nothing in the States.
Okay. So suppose
That's a pretty long answer, sorry, but
this is really interesting. So suppose there is $1 million, right? The settlement for the employee is $1 million. We have an executive level employee, and the employer, upon settlement, agrees to structure an RCA, right? So an individual. I hope I'm using the term correctly, but an RCA, individual pension plan, for
individual pension plan is for the registered piece that's below. That's for the part that fits within the CRA, the Income Tax Act limits.
Okay.
Okay. And the RCA funds above that.
Okay.
So
yeah. So I didn't know that, but I guess for the purposes of this video, I'm going to use the term individual pension plan to
okay. Yeah.
Just a generic term. So suppose there is an individual pension plan, and the case settles for $1 million, and the employer agrees to structure a $1 million individual pension plan. Right? Are you saying that if the employee then moves to a different jurisdiction where they are where the laws of that jurisdiction, for example, no income tax whatsoever, they could take that money out of the individual pension plan tax-free in that jurisdiction?
Well, it depends on the tax treaty with that country. U.S. can't. I'm dealing in the example that I illustrated that was dealing with the U.S.-Canada tax treaty. Okay. So you have to look at, okay, what is Canada's tax treaty with that particular, with the Bahamas or with the Cayman Islands or, wherever it is that you're moving to, Ireland, right? Sure. Ireland, for example, doesn't tax offshore income. Interestingly enough, I've seen that used too. But so yeah, it depends on what the tax treaty says. Most of them, from what I've seen, and I've looked at quite a few of them, most of them provide pretty much the same type of treatment as we have with the States, where it's 15% withholding in Canada if it's periodic, and 25% if it's lump sum.
Okay.
So that's all the tax you would end up paying on that from a Canadian perspective. And if the other jurisdiction is tax exempt,
doesn't have any taxes,
then that's all you've paid on that income.
Okay. Yeah. Interesting.
I saw somebody move to Ireland and do that actually.
Okay.
They left it in the Channel Islands and they don't tax offshore income.
Okay. And would that person to take this money out of the individual pension plan, that person in this non-Canadian jurisdiction, would they have to be a tax resident of that non-Canadian jurisdiction, or could they still be a Canadian tax resident when they're trying to take advantage of the lower tax rate?
No, you have to no longer be a Canadian tax resident.
Okay. So
you'd have to be, and you have to be tax resident somewhere. So okay. You would in the example that you gave, you'd want to be tax resident of that jurisdiction that you moved to that had low tax, and that that triggers off some fairly complex tax planning, because when you leave Canadian tax jurisdiction, when you give up your Canadian tax residency, you have a deemed disposition of all your assets.
Can you explain
for tax purposes?
Okay.
I have a deemed disposition of my house. Well, that's okay because it's a principal residence. It's tax exempt. I have a deemed disposition of all the shares that I'm holding outside of my plans. Maybe I've got a bunch of shares sitting there from some other venture. I have a deemed disposition of that. So I have taxation on all of the accrued gains, capital gains in those shares, even though I'm not disposing of them actually. I have a deemed disposition of them. So from a tax perspective, it's just as though I sold all those shares.
Okay.
Right. If I have a cottage, right, second residence, it's now I have a deemed disposition of that cottage as well. So you have to look at the whole picture. For some people, it's pretty simple. If I'm a U.S. expat and it was up here and I don't own much up here and my stuff is all in the States, then I'm in good shape. But if you're dealing with somebody who's in Canada and has accrued a lot of assets up here, well, then you have to look at everything and say, okay, what is the full tax impact going to be on this? Yeah.
Um, and this may be a really silly question, but when you no longer when you no longer become a Canadian tax resident, is that like a form you submit to the government? Do you declare it?
Yeah,
How do you no longer become a
yeah,
Canadian?
it actually is. There's a very formal process that you go through, and it's easy to see checklists where you have to give up, get rid of your Canadian bank accounts, get rid of, resign any clubs that you belong to. You have to be able to demonstrate that this checklist of items like that is it's all designed to show whether or not you were intending to move away from Canada in the long term, if not permanently.
Oh, okay. So
As
you
opposed,
can't
as opposed to I'm moving, it's a sojourn, I'm moving away temporarily.
for sure. So you
Yeah.
can't have Canadian bank accounts to be a non-Canadian tax resident.
Well, you could mm, you might be able to get away with having one to receive, if you've got Canadian income and you need some facility for it to go into. Um, but basically, as I say, the key thing is all of your actions have to demonstrate that you intend to move away from Canada and not come back, right?
Okay,
So it's not like you're just temporarily moving away. I'm leaving everything in place. That's why if you're a member of the Granite Club, you resign your membership at the Granite Club, et cetera, right? Ski hills, golf courses, blah blah blah. Um,
this may be a little bit because it's a very interesting topic. This may be a little bit outside of our conversation today, but presumably you would no longer be entitled to OHIP and other government benefits if
that's
you're.
right. Yeah, yeah. And then there are rules in terms of if you do come back eventually, which some people do. They, circumstances change, whatever, they end up coming back. For OHIP, for example, there is about a 3-month waiting period to get back into OHIP coverage.
Okay,
So you'll have a gap period where you're actually not covered. You might need insurance for.
for sure. And my
Um,
understanding, and correct me because I'm not the expert on this, but that you actually can't be in Canada, I think, for more than half a year if you're a non-Canadian tax resident. Like you're physically not allowed to. Is that true? There's like a time limit as to.
I believe it depends on what kind of a visa you have, right? You're talking about people coming into Canada?
Well, I'm talking about like this. Suppose we have this hypothetical scenario where we have this individual who decides to renounce their Canadian tax residency.
Yes. Okay.
And I'm making a distinction here, and again, jump in if my distinction is incorrect. But Canadian citizenship and tax residency are not the same.
No, you're
You can
not. No.
be a Canadian citizen and hold a Canadian passport,
Yes.
but you can now be a tax resident of a different jurisdiction.
Precisely.
Okay, that you're
Yeah.
not a citizen of that jurisdiction, but
Yeah.
you're a tax resident of that jurisdiction.
Yeah.
I read somewhere that if you declare yourself to be a non-Canadian tax resident, you can't then be living in Canada for more than I think it was approximately half a year. Now my
Oh,
number.
I see. I see. Yes. Yeah. Yeah. That's right. You have to be. I think the limit is. I think they call it sojourning. You have to show that you're sojourning, and it's like 1 day less half a year or something like that. Yeah. Yeah.
So,
That's
so
right.
it sounds like it's actually a fairly complicated. So given our hypothetical, we have this person with an individual pension plan. They get $1 million, but if they want to take it out in a different jurisdiction, they would have to declare themselves to be a non-Canadian tax resident. And
That's right. Yep.
yeah, and then there would be a deemed
Yeah.
disposition of all their capital gains and
Yeah.
second
So,
property.
if you're going to be use the simplest scenario, if you're going to be like a snowbird, but you're going to be spending, more than half a year in the States every year, you could do that. You could set it up that way, and you come back here for the summers.
Yeah, for sure.
Um, Interestingly, I had a case where I was asked to look at all of the provinces, and this was a few years ago, and I'm relying on my memory, but all the provinces for OHIP coverage in terms of how long do I have to live in each province in order to maintain my Medicare coverage. And on Ontario, it's five months. The shortest that I found was Newfoundland was 4 months.
Oh, wow. Okay.
So you could live in Newfoundland for 4 months of the year and be in the States for 8 months or wherever, and still maintain your Canadian medical coverage. Theoretically, it was possible, and this was a person who moved all over Canada frequently. And I discovered that, in fact, if you don't spend enough months in each province, if you move frequently enough, you could actually have no coverage, even though you're in Canada the whole time. which was surprising to me. But anyway, that is one of the other things that people often consider when they're looking at changing their residence,
Okay.
or going to the States for a lot.
For sure.
We get a lot of snowbird questions.
Okay, so let's go back to the original scenario. So far, to summarize, we've talked about defined pension. We've talked about individual pension plans with some creative options for people to become non-Canadian tax residents.
Yeah.
Now, often when we at my firm, when we structure settlements, we look at straight income, retiring allowance, or general damages. Structuring a settlement in one of these three forms.
Mm-hmm.
Is that something that you often see in your practice in terms of choosing the best structuring of these three?
Yeah, and trying to put some into, if possible, human rights damages, so it's tax exempt, right?
Yeah, for sure.
Difficult to do in many cases, but
yeah. Well, would you like to comment and describe the difference between straight income, retirement allowance, and general damages to our audience?
Well, general damages and straight income are both taxable at regular employment rates. Where you can get tax exempt damages, there's the CRA has a folio, I forget the site just off the top, where they set out their policy on what the tax treatment is of all the different types of damages. In their view, anything that you get, other than some fairly narrow exceptions, falls into the category of retiring allowance.
Okay.
In from a tax perspective.
Sure.
And so that's taxed at regular retiring rates. If you have enough RSP room, you can put the money in an RSP. Used to be that retiring allowance generated its own RSP room, but those days are so far behind us. I don't even remember. I think it was pre 79 or something. I can't even remember now. It's been so long since I bothered to look at that. But used to be that you could shovel some of the money into extra RSP room under the in the old days. But the CRA's position is that if the settlement, if the damages relate to human rights issues, that those are tax exempt.
Yeah.
And so that's the best way to structure it. Sure. To the extent that you can.
Yeah.
But yeah, they have taken, I think some people would argue that they have taken an overly restrictive approach to the categorization, basically, of anything you get in respect of termination of employment is a retiring allowance. But that's essentially, other than, as I say, some fairly narrow exceptions being relating to human rights.
Yeah.
Yeah, I've never looked at fighting that, because nobody wants to. You never get settlements that are big enough that it's worth duking it out with the CRA about the characterization.
Yeah. Here's a question I have for you, and often this is a conversation I have with opposing counsel when we're structuring a settlement. And suppose this is a scenario where there is a legitimate human rights ground. and we structure some of the settlement as general damages under the Human Rights Code, which is tax exempt, and another piece as either retiring allowance or income subject to statutory deductions. So the conversation I often have with opposing counsel is that opposing counsel says to me, well, we can't structure more of this as general damages. And let's suppose this is a situation where we pled, say, $1 million in general damage, right? It's in the pleadings, but the actual settlement is smaller than the amount pled. Opposing counsel would say to me, well, we're afraid that the CRA will audit this particular settlement, and, you know, beyond X amount of general damages. So we open ourselves up to liabilities. So we can only structure, for example, 50% of this as general damages, or 25%, or some whatever numbers. Different people have different metrics, none of which I don't think is very empirical, but they have their own comfort levels as to how much general damage versus retiring allowance that's split. And my question to you is, in your practice, have you ever seen an employer actually be audited based on a settlement that was partially or entirely general damages under human rights?
No.
Or,
nope.
no. Okay.
I've never seen one audited. Never.
Okay.
And I've been involved in a lot of cases.
Yeah.
And I know what you're getting at. What I guess one of the key distinctions is the withholding amount. With general damages, the withholding requirement is only 30%, right? As opposed to regular employment income. You know, if you're at the 50% marginal rate, then they're withholding at 50%. But at the end of the day, you know, at the end of the tax year, the employee's got to pony up the additional amount that wasn't withheld. So that's, I presume that's why you're trying to characterize more as general damages, is to avail yourself of the lower withholding rate.
Yeah, that's one thing that we're trying to do.
Yeah.
Well, in the human rights case, as you've rightly pointed out.
Yeah, then you want to be, it's tax exempt. Yeah.
So we try to get as much of that as possible for the
Yeah.
client when we're structuring a settlement. But again, you know, opposing counsel will often say, well, it's because, you know, there's all this audit risk, and it's refreshing to hear from you that you've never actually experienced any tangible audits of you know, an employment, for example, a wrongful dismissal settlement. That's maybe $50,000 or $100,000 at most in terms of the value of the settlement.
It'd have to be a pretty eye-popping settlement. Let's put it that way. Yeah. I had one client that had a T4 that was over $200 million.
Wow.
That was, and it had some very interesting large deductions involved in some tax planning that I'd done. So that was scrutinized pretty closely.
Okay. How does $200 million, and how can I be
$200 million T4? Yeah, I'd never seen so many zeros. It was like,
what did they do?
They were a CEO.
Okay.
Yeah. Right. I know, you know, it was private equity. So they basically had an incentive plan where, you know, if he drove the value of the business up, he got a piece of that, right?
Okay, amazing. So we've dealt with, in this conversation so far, settlements. Let's move back to an earlier comment you made, which is, how do we structure compensation for employees in the most tax efficient way at the onset in terms of the employment agreement?
Yeah.
And the compensation offered. Yeah. So what are your insights there?
Well, I'll give you an example of something I was working on not very long ago. Employer, remote location, difficulty attracting and retaining employees because of that. So saying, you know, we're willing to pay fair market. We're willing, in fact, to pay 75% of fair market value for these positions, right? But even that doesn't seem to be enough to get people to come and stay. So what can we do? So we start looking at it and saying, well, okay, you can look at the individual's circumstances, put in a benefit plan that has healthcare spending accounts, flex dollars, right? So the employee that you're trying to recruit wants, give you an example. This was an extreme example. This one particular person had a special needs child. And this special needs child, her care cost a 6-figure amount was well north of $100,000 a year. So at the time of hiring, we arranged that I forget what the person's pay was. It was probably, I'm going to guess it was probably $500,000 or $600,000 a year or something. We arranged that about $150,000 of their pay was flex dollars. So fully tax deductible to the employer, right? It doesn't cost the employer any more than regular pay. Completely tax exempt for the employee. Because this was a dependent and it was all medically qualifying. You know, anything that falls into that you can get a medical credit for in the Income Tax Act also qualifies for private health services plans, PHSPs. So you can put it in the context of a PHSP and it's tax exempt receipt. So there's $150,000 that the person is getting tax-free to pay for his daughter's care. He at a 50% tax rate, he would have had to gross 300,000 to come up with 150 grand, right? Okay. To cover that. So there's an extreme example of a way of getting a lot more bang out of your compensation buck. For the average, person, your kids might need braces. Okay. You might want LASIK eye surgery, right? You might want some cosmetic dentistry done. These are things that, because they're done by medical practitioners, qualify for PHSPs, but plans don't generally cover them. But you can put in healthcare spending accounts, your flex dollars, to allow the person to pay it with pre-tax dollars. Okay. Right. And if you're doing this at the initiation of the employment relationship, right, the CRA can't come back and say, oh, so much of this should have been taxable employment income, right? The CRA has a strange position with respect to that. Strange from the perspective of people like us who are employment lawyers, because basically they take the position that once the employment relationship has started, right, you can't subsequently convert part of their salary into tax exempt PHSP dollars. So we can't agree to decrease your salary by 20,000 and give you 20,000 they say that that's not valid. But of course, as an employment lawyer, and you look at that and say, well, of course, two parties to a contract can renegotiate it anytime they want to, right? CRR position is once you're an employed, you can only do something like that when the contract expires, which from an employment law perspective makes no sense whatsoever. But anyway.
Okay. That's really neat. Well, let's take a look at some other topics. Prior to our conversation, you sent me a list of topics that you want to discuss. So I'm going to go through this list here. So would you like to comment on the 2024 federal budget with respect to its impact on employer withholding obligations in respect of stock options?
Yes, that's put employers into a bit of an awkward position right now, because they've applied the same inclusion rate to stock options that they have introduced for capital gains, 66 2/3%. So 2/3 instead of half for amounts above $250,000 in a particular taxation year. Now, here's the problem for employers. I've given you stock options. You're going to exercise some this year. I need to know what withholding rate to apply, but I don't know what you're going to be doing with capital gains. But the legislation, the way it sits right now, and they're supposed to be coming out with some clarifying notes at the end of July. But the legislation would require that I know how much you are going to have in capital gains and how much you're going to have in stock options this year, so that I know whether you're underneath the $250,000 limit or over it. And more, to add to the complexity, the employee is entitled to allocate, where they have both, they're entitled to allocate which one falls underneath the 250 and which one falls above the 250 between their capital gains and their stock options. So, realistically, what can the employer do? Well, they pretty much have to throw up their hands right now and say, I'm going to tax you as though it's all above, as though it all falls into the higher inclusion rate. And you file your taxes, and if you're eligible for the 50% inclusion rate, you're going to get a refund at the end of the year. Sorry.
Okay.
Yeah.
This is
So that's
to the new budgetary rules that came out this year.
Yeah. So it just puts employers in an awkward position. And the only prudent course of action that I can see right now is you just have to assume that it's going to be over.
Yeah. Okay.
The $250,000 limit.
Okay. The next topic, I think we already touched on this. Use of retirement compensation arrangements and individual pension plans for key employees and U.S. taxpayers.
Yeah.
Is there anything else you want to add to that, or have we covered
No,
that?
I think we gave that a good canvassing. Yeah.
Okay. So the next topic you wanted to touch on, taxation of restricted share plans versus share set of restricted share unit plans. The former are often substantially more tax effective despite being taxed at grant rather than at receipt. So maybe you can talk about this.
The conventional tax wisdom is a tax dollar deferred is a tax dollar saved. So everybody likes to defer, right? And this is an anomalous exception to that, depending on the circumstances. If you have restricted share units, and let's say they're a 3-year vest, which is typical, they're not taxed at grant. They are taxed at the time of receipt 3 years down the road. Let's assume that the share at the fair market value of the shares, the underlying shares, was $10 each at the time of grant, and they've gone up to 20 at the time of vesting and distribution. So I'm going to get $20 a share. The full $20 a share is taxed as regular employment income. So 53%, or whatever I'm at, depending on what province I'm in, et cetera, blah, blah, blah. But for most higher earners, it's going to be around 50%. The deferral is considered good because I've had the compounding of the growth of those shares effectively in a tax sheltered environment. It's kind of like an RSP, right? I'm not paying any tax until it's actually distributed. Restricted share is taxable at the time of grant. It's a share that I'm given at grant, but I can't sell it. So it's it's held by a third party. I can't sell it for, say, 3 years down the road. That's why it's a restricted share. The CRA allows us to recognize the fact that a share with restrictions on its liquidity is not worth as much as a share without restrictions on its liquidity. You wouldn't pay the same amount for an identical share that you could sell immediately and one that you couldn't sell for 3 years, right? And so you can get these, you get professional share valuators to do a calculation where they determine what the appropriate discount is to the value, the fair market value of that share due to the restrictions on its liquidity. And it's similar to a Black-Scholes type of calculation. So the higher the volatility of the share, the higher the beta of the share, the bigger the discount is going to be. The lower the dividends are, the higher the discount is going to be. Those are the key driving factors. So you might end up with a discount of 30, maybe 40%, depending on the characteristics of the share in terms of its trading history, right?
Okay.
Now, so I pay tax on, instead of $10, let's assume it's 40%, 40% discount. Instead of $10, I pay tax on $6.
Sure.
Fair market value of that restricted share. So if the share does nothing other than hold its value, and it's still worth $10 when I can sell it. That $4 is capital gains. It's taxed at half the regular rate, right? Normally that would be a full income inclusion.
Sure.
So I'm getting capital gains treatment on part of the original fair market value of the share. Now, in our example, the share went up to $20. That difference between the full difference between $6 and $20 is all capital gains.
Okay.
Right. That $14 is taxed at half the regular rate.
Okay.
Right. So I'm paying, I've paid tax at the front end on $6, but I'm getting capital gains treatment on the difference between $6 and $20 at the end. I'm way ahead of where I would be with restricted share units.
For sure.
Okay. Right. So that can be very worthwhile for executives, depending on the characteristics of the underlying shares. If you've got shares with really low beta, high dividends, you're only going to get a discount of 10%. Might not be worth doing.
Okay, interesting.
But if you're say you're more in the like a junior exchange where you got high beta, lots of volatility in the share prices and stuff, no dividends, it could well be. I've put it in clients where they were very, very happy at the end of the day because they got big discounts at the front end, big upside on the shares. Yeah, all capital gains.
Amazing.
Yeah, so it's an interesting thing. And as I mentioned earlier, I've seen a number of instances where there was people were taxed in as though they had restricted share units when they should have been taxed. The withholding should have been done on the basis they're restricted shares. In the States, in the U.S., and this was in every instance, this was a U.S. parent of a Canadian sub. And with the U.S., they can have a restricted share plan, and you have the option of electing to take it into income at the front end. I think it's 83B. I can't remember what it is in the code in the States. But if you don't make an election, it's deferred until you can actually sell them. So they taxed them on the basis that the rules in Canada were the same, and they weren't. And as I say, it made a huge difference. In both these cases were wrongful dismissal cases, right? And we were calculating the damages, and so we needed a gross up, big gross up to make up for the fact that they taxed them wrong. Yeah.
The other topics you suggested, damages gross ups for tax deferred compensation arrangements, and damages gross up in respect of tax jurisdiction and marginal rate differences. Do you want to discuss one or either of these?
Sure. Very quickly, I mean, the obvious example is stock options. If I would have paid, if my options would have vested during my notice period, right? So I would have, and I don't have any completely unambiguous language excluding that LTIP, blah, blah, blah. Then I would have received, $300,000 and paid tax only on $150,000 of it. Yeah. Assuming they're all qualifying options.
Sure.
So we need to gross up the award because at the end of the day, I'm going to pay full tax.
Yes.
Right. So you might make the same argument with respect to some deferred compensation, some other deferred compensation plans, restricted shares, I've mentioned, pension plans, right? If I'm not accruing, let's say that I was 24 months. The finding is that I was entitled to 24 months notice. I should have had 24 months more accrual. Now you have to pay me all that accrual, that pension plan accrual outside of a sheltered plan. You're going to have to gross it up,
yeah,
right?
Sure.
Yeah. So they all go to special calculations of damages to account for the slippage in tax efficiency that results from having to have a straight income inclusion as opposed to a tax preferred income inclusion, which would have been the case. The latter would have been the case had I continued to be employed throughout the reasonable notice period, right?
Sure. Had you actually worked this holiday for a month,
Exactly.
a salary continuance as working notice.
Yeah,
That would be
exactly.
the analogy.
Tax jurisdiction marginal rate differences. I've seen a couple of cases. I don't remember the sites just off, Randy, but I saw a couple of cases where the person had to move from province A to province B in order to mitigate their damages, right? And province B had a substantially higher tax rate than province A.
Okay.
And the court grossed up the damages.
Oh, okay.
Because they were going to have to take all that into income in province B, and I thought that was quite interesting.
Okay, interesting.
Yeah.
That's very interesting.
Yeah.
Do you want to comment on the use of hybrid restricted share unit plans?
That's that's a it's complicated. I'll try to keep this straightforward, but essentially, as I mentioned, with restricted share units or performance share units, any type of share unit, the inclusion, when they finally vest and they're paid out, is all at full employment tax rates, right? So the question in my mind was, well, how do I structure this? Is there any way I can structure this to capture all the growth in the stock value post grant in a more tax friendly environment? So the idea I came up with was, okay, the share unit will have a stock option cap or hat. Okay, so I'll have a share unit that can't grow beyond the grant date value. Grant date value, let's say, is $10,
Okay.
right? If the share falls to $5, it falls to $5. If it goes to $12, it's still only $10. It can't exceed the grant date. All the growth post grant is collected in the stock option.
Okay.
Okay, so I got a stock option here, qualifying stock option, and so if it goes up $2, that's taxed, assuming I meet the qualifications limit of 200,000 for grant, thanks to the third last budget, and $250,000 maximum for the 50% inclusion rate. Going forward, just assuming that that's the case, I only get taxed on $1 of that $2 gain. So with this hybrid structure, all the growth going forward in the share value is captured in the option and taxed at, if I've structured it properly, it's taxed at half the regular rate.
Okay. Interesting.
Yeah.
Right.
So and I put that in place and had absolutely enormous savings for some people who had really big stock option grants in private equity situations.
Okay, that's very good to know for my clients who may be in those situations. And I guess finally, as we're getting close, we're now exceeding the 1 hour mark here. Comments with respect to Matthews versus Ocean.
Oh yes, actually, I helped Stacy on this. We had intervenor status on this case. It was interesting. It was the first Supreme Court case that I'd worked on. Oh my God, it was a lot of hoops to jump through. Getting an agent in Ottawa and stuff. Anyway, interesting case from the perspective of LTIPs and also good faith dealings for obligations on the part of employers. There's always been the obligation, as you know, in the past, the employee has, have to be dealing good faith dealings with the employer. They were always loaded up with these obligations, and the courts were slow to start leveling the playing field and saying, well, the employer has those types of obligations as well. Ocean Nutrition expanded that somewhat and also made it clear that with respect to LTIPs, you have to completely unambiguously exclude them from vesting in the notice period if you're going to have them not vest during the notice period, right? And that was one of the main points of contention. And I see that BC and Taylor, which just came out in 2024, British Columbia Court of Appeal, this was in respect of the pleadings. The employee had an argument in their pleadings that there was bad faith on the part of the employer, going back to 2012, when they weren't actually dismissed, and they were dismissed without cause in 2017. All right, so quite a few years later, the employer, the province of British Columbia, not surprisingly argued that those pleadings should be struck because the only thing that's relevant in terms of good faith in a without cause dismissal is the employer's actions at the time of dismissal. The important thing about this case is they said, no, this is an evolving good faith obligations on the part of an employer, is an evolving field of law, and we're allowing these pleadings to remain because we want to allow novel arguments to be made in terms of good faith obligations on the part of employers. And I sort of relate that back to Matthews as kind of opening that up more. But anyway, I thought that was a very interesting case, and troubling for employers.
Sure. All right, final one here, and this is interesting because I didn't intuitively think that there was a taxation implication here, but you tell me. Implications of absence of apology on potential for reinstatement in sexual harassment cases.
Well, it's more of a I was involved in a case of sexual harassment, and I did this big spreadsheet looking at it was a CLC regulated Canada Labor Code regulated employer, and I could not find a single case where there wasn't an employer or an apology, and they exercised their power to reinstate the person. The only tax implication is that, instead of being back at work and earning things in the regular course, obviously, if you got back pay, you would be taxed on the back pay. You'd be being taxed on a lump sum,
for sure,
a payout. So it wasn't really so much of a tax angle as just as I say, I just found it was interesting. I looked at I can't remember how many cases, a lot of cases, including arbitrations, because we're talking about just cause, and no reinstatements where there wasn't an apology, period. No apology, no reinstatement.
Okay, well, I think that's logical, all right? That's logical. Okay, well, Rick, do you want to tell the wider audience what you do, what type of work you're looking for, and how people can contact you?
Okay. Basically, I'm working part-time, and sit on a few boards, and I'm helping a few firms out in terms of kind of as a backroom person in terms of case strategy and in dealing with particularly with more complex damages issues involving taxation and structuring of settlements. And that's on the wrongful dismissal side. On the employer side, I guess probably the most succinct way to put it would be I'm usually involved in figuring out how to get more net dollars out of the same cost to the employer, how to get more net dollars to the employee. So more bang for the compensation buck. And as we've discussed today, there are quite a few ways of looking at doing that.
Okay, amazing.
Yeah.
Anything else you want to add? As
I can be, well, you know, I can be contacted at 647-299-3357, or richard.c.schubert, that's SCHUBERT, at gmail.com. So yeah, I find I'm probably particularly valuable to smaller firms or sole practitioners who are engaged in the employment law, HR law area. That's probably where my background can be most helpful.
Okay,
All
amazing.
right.
Well, Rick, thank you for your time today. It was a
Oh,
pleasure
you're welcome.
speaking to you. And good luck with all the wonderful tax structuring and maneuvers that you're doing. It's a fascinating world.
Yeah, it's an interesting sideline of employment law.
Yeah,
Yeah.
absolutely. Thank you.
Okay. Take care, Randy.
Bye-bye.
Bye.